Alex here with a video on legal nuts and bolts. This topic is going to cover motions for reconsideration and a little tiny bit on motions for a new trial. This is one that I get a lot of questions on. Man, like I want to use I want to say 99% of people who get a decision that they don't like in their child custody case, and I was one of them early on. The first thing that you want to do when you read something in an order that you don't like, at least this was true for me and for a lot of people that contact me, is you want to get the judge to change their mind. And so it's like a go-to for people to file a motion for reconsideration. I've even seen some lawyers want to do this. In my experience, the motion for reconsideration is a total joke and a waste of time. And it seems to me like it just pisses the judge off. I covered a little bit. There's 3 videos I want to tell you to look at if you get a chance to sort of give you a foundation as to what I'm talking about here. The first one is filing an appeal, because I'm going to talk about that. The second one is the standard of review on appeal, because you should know how that works when you do file an appeal. And the third one was the video that I did on overcoming lies moving forward, because I talk about how generally the court system moves forward. Anytime you're trying to get the court system to look back on something that it has done, it's what you're trying to do is hard, and it could cost you credibility, because you're just going to look like all the other self-represented people that are going bananas because they don't like their decisions. I talked about this a little bit in that third video that I mentioned. If you don't like your decision, you have to either challenge it or live with it. If you challenge the decision and you lose, so like if you file an appeal and you lose, you have to live with it. I'm going to go into that in a second. Challenging your decision. Please don't file the motion for reconsideration, at least not in Nevada, because it never works. I've never seen it work. It just, it's just a waste of time. It's so bad. And it's some people file like 2 or 3 on the same decision, because it's like the judge said something they don't like, and it's like, well, he must have not understood me. He must have got something wrong. And it's like, no, he usually, okay, there's 2 things that happen. Either he did understand you perfectly and disagreed with you, or he didn't understand you, and filing a motion for reconsideration is not going to make him change his mind. It's like I've never seen them work. I imagine that it might work in a situation where like you got a judgment for $1,000 and the judge accidentally put 100. Like he missed a 0. I imagine that would work. Motion for reconsideration, you forgot to put a 0 on the end of that 100. That probably would work. Maybe, okay, there was one time when I had a decision from my judge based on Rivero 2008, and then in 2009 they changed it. So it was like Rivero 2008 came out and I had this decision, and then like boom, Rivero 2009 came out replacing what happened in Rivero 2008. Maybe I could have done that there. I mean, that sounds like something that makes sense, because it's like you're not telling the judge you missed something, you're wrong. You're telling the judge you were right, but the law changed, so please change your order. Those are like the rare, weird occasions where you might get away with doing this. In all other cases, you're wasting your time and you're irritating the judge. Like I said, even some lawyers do it. I don't know. I feel like maybe people are just scared of appealing because it just sounds scary to go to the Supreme Court. It sounds expensive. For lawyers, they're just not used to it. You know, maybe a lawyer's been practicing law for like 20 years and they've only done like 2 appeals. So to them, it's like a regular court case. A motion for reconsideration, they've done those before. That's not that hard. An appeal is like, whoa, that's going to be a lot of work. I don't know what it is, but it's just like people don't like to appeal. And I'm telling you now, that works. I've done it. I've won 4 appeals, or I've won 3 appeals and 1 writ petition. So it's like when a judge makes a mistake, if I file a motion for reconsideration, I guarantee you I'm going to lose. The same judge, I'm going to the same judge who made the mistake and asking him to change his own order. It's not going to work. What I need for that judge to change his mistake is for me to get his boss to give him a direction. So I go over his head to the Supreme Court and I tell this panel of judges, hey, my judge made a mistake. So now I'm not going to the same guy who screwed up. Now I'm going to 3 different judges. And if they agree with me, they're not going to ask my judge to fix his mistake. They're going to command him to. They enter an order reversing and remanding, and they give my family judge in this situation instructions as to what he should have done. That's how you fix mistakes. It costs money. It's by the way, you can get a fee waiver. If you can't afford an appeal, you can get that fee waived in Nevada. So that's not an excuse to say you're too poor, because you can do it yourself. I'm not a lawyer, and I've done it myself, and I lost some of the earlier ones, but you know, that's part of the process, part of learning. It sucks to have to lose stuff to figure out how the system works, but it can be done. If I can do it, you can too. I know some people don't actually like hearing that, but what I'm going to do is I'm going to actually post online some of my motions that I filed when I was like a newbie, just so you can see how bad they were. Because people need to see that the first papers that I've ever filed were just as nutty and crazy as the ones I tell people not to do. So it's not like I'm just like a genius and I just like went into the court system and just knew everything. It's like, no, I started out thinking all these things that were wrong. I started out filing all these things that were wrong, that lost. I've lost my first few appeals. And after time, after paying attention and reading and learning, I figured out how to do the stuff I'm doing now. And so you can do it too, because I'm not saying you have to be a genius. I'm just saying you have to pay attention. So it's just, and it took me 8 years, so it's not like I did it fast. It took me a long time. So anyway, if you can't afford to hire a lawyer to file an appeal, you can file one yourself. And if you can't afford to file the appeal, you can get that fee waived. So yeah, don't use the motion for reconsideration with those curious exceptions that I mentioned that have to do with not putting a 0 on the end of a dollar figure or something, stuff like that. Use the appeal. Or please watch those other videos, because I did mention that please watch those other videos, because some things aren't appealable. And the things that are not appealable, in those other videos I explain the ways that you can challenge them. So for example, my ex got a fictitious address from the Secretary of State. That was not an appealable determination. So I challenged that with something called a Petition for Writ of Mandamus. Watch those other videos and I explain, because sometimes you have to challenge something using a different vehicle. That's what the court calls it, or a different tool. Getting back on track here, I did want to mention one extra thing is I have read some case law that says that the motion for reconsideration does not toll the time limit for filing an appeal. Now, I've seen other cases in Nevada that seem to say the opposite, so please don't quote me on this, because from my understanding is that this is not, there's contradictory cases out there, and I may have not read them carefully enough to give you like a solid answer. But I have seen some cases saying that motions for reconsideration do not toll the time for appeal. What does that mean? I'm going to probably cover tolling in detail in another video, but in a nutshell, these deadlines change in Nevada. When you get a decision from a judge and you get the notice of entry of order, you have 30 days from that to file your notice of appeal. If you do not do that, you cannot appeal. The Supreme Court literally lacks the authority to even hear you. That's what they've stated. It's not that they're trying to be mean. It's that under the Constitution, they don't even have the authority to hear you. So it's a serious deadline. It's not a joke. Some things can be filed that will toll the time to appeal. Like, for example, a motion for clarification. If somebody files a motion for clarification and then that motion is denied like 3 weeks later, well, the time to file the appeal starts from the time that motion was denied. Same thing for a motion for new trial. If somebody files a motion for new trial and that decision, you get like a decision back in 2 months, well, that's obviously 2 months later, so you're late on filing the appeal under the ordinary 30-day deadline, but it's a tolling motion, so it tolls the time to appeal. So the 30 days starts from the order denying motion for new trial. Now, like I said, I've read some cases, and I'm not going to go ahead and look into this because it's not really an issue for me right now. If it becomes an issue in the future, I may look at it again. But my understanding is that it appears to me that motions for reconsideration do not toll the time to appeal. So if you file that thing and then you get a decision back 2 months later, well, now you can't appeal because the deadline has passed, and the order denying motion for reconsideration does not toll the time to appeal. My understanding. If there's like a lawyer watching and they want to post something down in the comments, because I did mention I'm not absolutely sure about that, but please just post it down there and I can take a look at it. But this is just adding on to the dangers of messing around with going back to the same judge. It's like not only are you going back to the same judge who messed up, not only are you going to make that judge mad because he's already made a decision and now you're coming back. But then when he enters his order, you can't even appeal. So it's like, just don't do it. I did want to talk a little bit more about the motion for new trial. It's not really something that I've seen people do in child custody cases, but my understanding is that in a normal civil lawsuit for like money damages or for like a suit in chancery or whatever, if you lose your when you lose your case, like when the decision comes out, the judgment after the trial and all, you can ask the court for a new trial, some motion for new trial. My understanding is that those are taken a little bit more seriously than the motion for reconsideration that most people will file in like a child custody case. So for non-child custody cases, if you're doing a motion for new trial, I mean, that might be a legitimate thing to do. I have never done that before, but I do know that exists, that you can ask for a new trial, and you're basically telling the judge that there were some mistakes that the jury made or that the judge made, and that based on those mistakes, you deserve a new trial. I still think they get denied a lot because it's like you're going back to the same guy. So, I mean, my understanding is that those get denied frequently anyway. But, as I mentioned, those do toll the time to appeal. So when it gets denied, you can still go to the Supreme Court and ask them to review it. It's not like I mentioned with that motion for reconsideration. If I get a chance, I'll post a link to that case that said motions for reconsideration do not toll the time to appeal, just so people can see what I'm talking about. And in case there's like a lawyer and they want to say, well, this new case actually changed that or something like that. So with that, I'll go ahead and end this video. See you guys next time.